Yeah,
I think
because
right there will be good.
it takes 6
They have a
weeks.
warehouse that's super powered, so you can play 4K, 1,000 frames on that. Like, just because it's not the processing power is coming from your computer, it's getting processed somewhere else.
This is the
stream.
I
So it's a stream.
Then you can't.
So they're working on
I
that.
could, but they don't
Also,
scare me.
I can already do that. Like, I can go to
Okay,
my
I'm gonna pass out
downstairs
these
TV.
flyers. So some of you got that. I forgot to pass them out yesterday, Monday. So a few of you got it on the way out. Any extras you can just toss in the recycling. We have this last event tonight. Speaker series event tomorrow. Did I say tonight? I'm so sorry. I don't know where my brain is right now. I need to have more coffee.
I don't know, I like
So-
technology and the way where they're passing rates.
So what I do is I add 3 points to an exam.
Wow, I mean, either way.
Because it's really difficult. I want Canvas to accurately reflect everyone's grades, and then when I put in like extra credit for assignments and stuff, it starts looking really weird on people's things. So what I do, and how you'll see the extra credit reflected, is I'll be putting in the exam 2 grades this week. And then when you go and you pull up your grade, if you click it to open it up, you'll see your score. And then if I've added extra credit to that grade, you'll see in the notes section, it'll say includes +3, 4, and I'll say what it's for. So you should see within all your exams, like if you open up all your exams, you should see all the extra credit reflected. And if you don't, you have to come see me. So you probably all noticed, I always ask, like, email me to remind me, like that kind of thing. I do have short-term memory issues, like for real. It's a part of my autoimmune issues. So like you have to, but also it's your grade and it's your responsibility. So you have to go in after I post the exams and make sure that everything that you have earned is there. Because I don't have an ego. Those of you who have come to me, if I've forgotten something, you know that I'm like, oh, okay, let's figure that out. Because I know it's something I have to work with too. So by December 3rd is, by then, all your extra credit will be entered and you need to go in and look at it. And after December 3rd, obviously if you have something that's before final grades are fine. But once final grades are in, they're in and they're final. And it's like moving mountains to get a grade change. And it was really bad. So when I calculate grades, I go through it again, I check myself, I wait a day, and then go through all the numbers again. I run numbers multiple times. I export it to an Excel spreadsheet. I put in macros, I run the numbers there, so I know Canvas didn't make a mistake. Like, I'm neurotic about it. So I work very hard to make sure your grades are calculated accurately and you do everything you've earned. So by 12-3, this is when you have to confirm all your extra credit, your homework. If you've done a homework and for some reason it hasn't been graded, you have to like confirm your homework and extra credit. I have, no dress code. No dress code. And so we're going to start the content in a second. Yes.
Is there a limit for extra credit?
That's right.
A limit for extra credit?
So if you've gone to all the events, no. I mean, there's no limit. If you like, I feel like you get internable value from going to these events. And as an example, we want everyone to get the same information, so we should all have this be involved in the same conversation, right? I think there's a lot of value to this. I'm not just making that up. These are not like vanity events. I'm actually going to an event like this tonight, but in my industry, right? So I'm a lawyer. For me, someone who I need to hear, or who I would look up to, whose frame of reference I value, is a judge. So tonight, I'm driving downtown, dealing with traffic and parking, to go listen to a judge talk for an hour, because he's going to talk on a subject that I'm really interested in learning about. So that's how I'll spend my free time. So when I invite you to these things, it's not because any other reason except for I think that they do add tremendous value. That's why there's TED Talks, for example, like hearing different people's points of view and considering different options and alternatives. So I think it's very valuable to go. So whenever there's an event like this, there's no limit on extra credit. Like if I have an event, it's not like you can only go to 2 of the 3. Like I wanted to, but then I don't know. I feel like that's pretty incompatible with my learning approach. So you can go to all the events and get extra credit for all the events. If for some students the events just, they don't have their schedule because they're working, whatever. So I made the option of doing an outside research project or something, so that you can still have the opportunity. I want to have everyone opportunity available to everybody. So if that's the case for you, then there was supposed to be campus and you come talking about it. So any questions on this? Yes.
How long is it?
Okay, so some of these events I do in cooperation with our development department. So, you know, too many witches. They wanted the event to start at 5, but our speakers aren't starting at 5:30, which is why I disclose on here. They want everyone there at 5, just to make sure everyone's there. And I just have too much respect for people's time, so I think that's ridiculous. So there'll be pizza there at 5. You may come at 5, that's great. I'll be there at 5. Come before 5:30. The talk's going to start at 5:30. So that's why I like people to be there in the seats. It's going to last about an hour. If you have to leave early, that's fine. But about hour and 15 minutes is how long it's going to last. So and then we'll sign the sheet there. Any other questions? Yes.
I could have sworn when you wrote down the list of
I probably said there was a cap.
a limit of 2 events.
I know, but I don't want to limit you guys from going to this or disincentivize you. So more is more. It's not good for me because it makes it more difficult when all the grades, I have to start really distinguishing.
Right, but if we've attended the first 2 and skipped out on the rest, it's kind of
Yeah.
unfair, isn't it?
Yeah, so you can talk to me about that. So, but there's only been 4, right? So there's only been skipped out. So there was 4 total, right?
Right.
Including this one.
As a matter of fact, it was 5, including women in business, but you didn't list that one.
I didn't. We'll talk about it. I mean, I'm all for due process, right? I know, that's the thing. I didn't intend to do so many, except that the dean asked if we would encourage students to go to the tech event, and he personally asked me. And he said, it's okay if you give extra credit. It's like, because you're my boss, fine. So that's full disclosure. That's what happened. I wasn't going to actually send people to that one because he wasn't on my radar until he hit me up for that. So with that said, I have to make sure that it continues to be fair for everybody and that you continue to have the opportunity to make informed choices. And that no one is prejudiced by their by their
Why don't you use that as a
well, I don't read those alert things. I just click. So I mean, you can guess. I guess you read it. I'm gonna assume he just keeps pressing buttons until it starts working. Okay. Let's talk about the plan, and then I'm gonna press record. And we're done. Oh no! Oops, that was that. Stop. We're going to be talking about a few things today. I want to start with this discussion of the we're in chapter 43 now. We're getting into the role of directors and we're getting into chapter 43 now. So we're starting to discuss the role of the directors and the various corporate leaders and what officers do. In last class, we started talking about how the directors are elected and then the officers are appointed by the directors. And who elects the directors? Who votes to elect the directors? The shareholders vote to elect the directors. And to whom does the directors owe fiduciary duty to?
The shareholders?
The shareholders.
The stakeholders?
Yeah, the corporation, right, the shareholders and the corporation. So we expect the directors to act in the best interest then, right? You know, fiduciary duty means you have to put the interest of your principal above your own self-interest, right? You have to act in furtherance of your principal's best interest, even if it means foreclosing upon opportunities for yourself, which is why you can't earn a secret profit. You can't compete with your principal if you owe fiduciary obligation to it, right? Because your primary interest, the highest duty, is owed to your principal when you have fiduciary duty issued. So this is exciting, this lawsuit, for a couple reasons. First of all, because one of my really, really close friends was one of the lead counsel on it, and it's made her very, very wealthy. She throws fantastic parties. Second of all, it was the biggest shareholder derivative lawsuit of all time, the biggest lawsuit and the biggest settlement of all time. And I'll show you some videos that talk about the fact pattern and kind of, they're very short soundbite videos. It's a really, really intense process. It was this huge, massive corruption that not only involved this corporation, but also the government and different contractors that worked with the corporation. And it was just this huge, huge, huge thing. But there were a lot of stakeholders and shareholders involved. There were companies around the world who were shareholders in this corporation. Big, big, big companies, right? So my friend, she was traveling around the world all the time to go to board meetings for these large corporations and update them concerning the status of this lawsuit because they were plaintiffs in this lawsuit against this massive company. So it's Petrobras is the name of the company, and we'll learn a little bit about it.
The probe into Brazil's state oil company Petrobras is the largest corruption scandal in the country's history. With a daily output exceeding 2 million barrels of oil and nearly 70,000 employees around the world, Petrobras is one of the world's largest oil multinationals. It was a potent symbol of booming Brazil during Lula da Silva's two-term presidency from 2003 to 2010. But in 2009, an investigation began to peel back the first layers of what turned out to be a colossal corruption scheme with Petrobras at the centre. It prompted the launch in 2014 of a major inquiry dubbed Operation Car Wash. The scale of the scandal became apparent when former Petrobras director Paulo Roberto Costa cooperated with investigators in exchange for reduced jail time. He accused some 50 politicians, most of them belonging to the Workers' Party of Lula and his successor Dilma Rousseff, of receiving billions of dollars in bribes. Rousseff was chairwoman of Petrobras during much of the period in question. In September 2017, she and Lula were formally charged with racketeering for plotting to skim funds from Petrobras. The investigation revealed that a cartel formed by Brazil's biggest construction companies paid bribes to Petrobras directors and to politicians and political parties tied to the designation of these directors in order to win huge contracts. The bribes were calculated as a percentage of each overpriced contract. There was no real competition between the construction companies, and that allowed them to set inflated prices. Stolen money is also suspected to have been funneled to political parties, including the Workers' Party and the PMDB party of current President Michel Temer. Several prominent politicians have already been sentenced to lengthy jail terms for corruption, and scores more have been charged. In April 2017, Brazil's Supreme Court ordered corruption probes against around 100 politicians, including several government ministers and around a third of the Senate. Former President Lula was sentenced to nearly 10 years in prison for corruption in July 2017, but remains free pending appeal.
Big time, right? So I was thinking as I was driving in about today's lecture, and I was thinking about the different massive catastrophes that I've experienced, you know, with like Enron, which we're going to get into, that Ponzi scheme, like these terrible things that I just remember watching the news and like my heart sinking, feeling nauseous, all this, and I was wondering, okay, what did my students experience? Like what kind of massive financial business catastrophes have you experienced? Do you recall any? The market crash, right? But as a result of a bad actor, like Enron was a result of a bad actor, right? And Ponzi scheme, that's a bad actor, right? So, right?
That's not like a lawsuit.
It's not a lot of lawsuits, but it's not a financial, like not a financial fraud being perpetuated. Like a corporate actor, a corporate bad actor, acting in the context of this corporate capacity, causing large-scale financial damage to a lot of people.
Wells Fargo.
Yeah, right? Wells Fargo. Well, how did that cause damage?
They stole a lot of money from customers. They put a lot of pressure on the lowest paid employees, putting their hoops they have to jump through so high that they had to resort to very shady tactics to reach their goals, or else they'd get fired. Yeah, so they had to like open accounts for people. They had to do like 20 or 10 accounts per person. So that's not really possible. So they just, every person that came in, they would just open 10 accounts for them.
Yeah, that's bad.
Stuff like that.
So the board I sat on, we were actually looking for somewhere to place some money we had for settlement, and we already had an existing account at Wells Fargo. They just refused on morale purposes to place the money, and we had to open up a different account so we could place the money there. Yeah, that's bad. That's bad. But in terms of scale, I think we've been, maybe it's because of all the massive legislation, all the red tape making like everything more difficult, but also maybe perpetuating fraud. We haven't had some massive thing here. But in other parts of the world, there have been these massive, devastating financial harms caused by bad actors, like these bad corporate actors. And it's interesting because you think about it, and it's like Harvey Weinstein, for example, it's not a financial thing, but it's a bad actor thing. He's going and doing terrible things, but it's impacting him and his victim. And maybe when it gets to a larger scale, then it ended up impacting the company because it's a reputational damage, right? And a lot of the people that we studied when we were studying sexual harassment, each row had a different person, right? And you look at them and you see the company took really swift action because they didn't want to experience that reputational damage. One reason why they had to do that, why the board of directors would have to take that swift action, is because that reputational damage harms the shareholders and all the stakeholders, right? The company's worth less, especially if it's a public company, then they have to utilize their business judgment and make sure they take remedial action in order to prevent this. These corporate actors, they go to work, like you go to work. These people also have 24 hours in the day. Like these people on the board, those pictures you see, the politicians, the board of directors, like they have 24 hours in the day, they get up in the morning, they have breakfast, they have spouses, they have families, they go home, they get tired, like they're humans, they're humans. I think sometimes we look at these bad actors and we conflate them and think that they're like some super evil villain. But like they're going about their day just like we are. It's just that within their day, they're doing more scandalous things and making more scandalous decisions that are affecting a huge number of people. Like my day, I feel like my day affects a fair number of people. I have 100 students, and I really feel like I need to bring my best self because it's going to impact, right? But we're talking millions of people. And like, if I come in a bad mood and I'm like really mean, maybe you're like, oh, she's a jerk, and you walk out, right? So like, my bad action, it might not have the consequences that these people have. But you all could possibly be in a position where you're making choices that'll impact others. And hopefully you will be in a position where your choices are impacting a lot of people. Hopefully you will be, because then obviously you're a great success. So what I find fascinating about this is not only like the bad act, but like the human aspect of it. Like you're going about their day just doing these things that it just adds up and adds up and adds up and it becomes this terrible thing. So based on this scandal, Operation Car Wash is what the investigation was called, a firm called Pomerantz launched this lawsuit.
A U.S. judge has told Petrobras bosses to prepare for a $98 billion lawsuit over allegations that executives at the Brazilian oil company and senior politicians were involved in a huge money laundering and corruption scheme dubbed Operation Car Wash. U.S. District Judge Jed Rakoff on Friday threw out Petrobras' efforts to get the case dismissed and told the company and investors who are bringing the class action lawsuit to prepare for a trial as soon as February 2016. Senior executives and Brazilian politicians are likely to be called to appear before the New York court if the case gets the final go-ahead.
So I was having a hard time finding really short soundbite videos, so we're just giving you a little bit of a status update. So this video talks about the lawsuit that was filed by the Pomerantz firm in New York District Court. So District Court tells us that it's federal court. Why would they be filing in federal court instead of state court? Yes?
Maybe the federal court is probably going to give a better ruling. They might not like their district.
Yes, the federal court is definitely, well, because they handled this type of case, because it's more of a federal question, it's based on federal statutes, like, SEC rules and regulations and those fraud issues, those are federal statutes. So they have federal question jurisdiction, and these courts are the ones who deal with this, and so they're going to be the ones that render the most, well-reasoned decision. Those are the judges who are most well-versed in this, so very good. So New York District Court, it's a class action, and they're starting to use some language that we read about in our book, right? So this is a shareholder derivative suit. It's a shareholder derivative suit. So, anyway, what's a class action? Yes?
It's when like more than one person, but like a lot of people have like the same issue, and like they all kind of come together to sue.
Right. So a class action is a litigation device. Under the federal rules, it's Rule 23, and you have to have a group of people that is so numerous that it would be inefficient to litigate those separately. So most courts will say like, over 30 is definitely enough plaintiffs, right? So if you have at least 30 people who are impacted, then the court will generally say you have sufficient numerosity in order to make it more judicially economical, right? So save on everyone's time, and to bring 30 separate lawsuits as opposed to one lawsuit where you all get together. Then you have to establish the claims are typical, right? So the claim of the representative plaintiff is typical of the claims of all the other class members, and so it makes sense to bring them all together. The representative will adequately represent the interests of all those class members because their claims are typical. They have the same motivation, right? The same injury. Then you have to prove the class member is adequate in that they have retained adequate counsel who's experienced, right? The judge wants to make sure that the attorney is experienced enough to represent all these people's interests because the consequences are more severe when you have more clients, and that the class member is also well-versed and has the time to devote to the litigation. Finally, you have to establish predominance. You have to establish that common issues, like the problem, injury, and the harm that everyone experienced, predominates that lawsuit. Like people can have their own kind of little discrete thing. We're all different circumstances, different people. But you have to prove that basically everyone has the same issue. These common issues predominate over any minor issue. So it's you don't have to know the law of class action or the four-part test, but I share it with you because I want to give you the framework within which these cases are brought. So you want to have this sameness, right? This common nucleus of operative facts that give rise to the lawsuit. So that's a class action in general. You'll see a lot of employee class action lawsuits. You'll see a lot of consumer class action lawsuits. If you've received something in the mail that says you may have been a party to a class action, who's received one of those? Right? And usually, they're opt-out classes, which means you do nothing and you get a check. If you get the check and you cash the check, you're bound by the terms of the settlement, which means you can never bring a claim against that defendant. So that's class action in general. Now, shareholder derivative class action lawsuit adds another layer to it, right? Because now, and we have a class action, there's a lot of interest going on, but it's shareholder derivative. So what's derivative mean? There's a few different meanings.
Branches off something.
Yeah, that's exactly what it means here, right? So the rights that the shareholders are enforcing are the rights of the corporation. And the shareholders are up here, right? There's all these different shareholders. But the shareholders are suing on behalf of the corporation. So the rights that have been violated are the corporation's rights. And but wait a minute. We expect directors to be advancing the corporation's best interest, right? They're the ones who are fiduciaries and who are supposed to get together and have their meetings and vote and all of that. So why would the shareholders have to advance the corporation's best interest when it's the director's job? Yes?
When it's the directors that are the ones that the suit is against.
Exactly. So when it's the directors who are harming the corporation, they obviously can't be trusted to bring the shareholder derivative lawsuit. One of the first requirements, and we'll get to it when we talk about this PowerPoint, one of the first requirements is that the lawsuit has to be tendered to the corporation. You have to tender it to the directors and prove that they're not going to go anywhere with it, right? Or you prove that that would be futile to do so. So yes, the shareholders will bring this case, but it's derivative on behalf of the corporation. So they're not talking about their own injury. That'd be a different kind of lawsuit, right? They could get together and sue for their own injury, like if their stock prices were damaged or harmed because that's their personal financial issue. Here they're saying you harmed the corporation, and so I'm suing on behalf of the corporation. It's like if your kid is in a car accident. Your child doesn't have the capacity to bring their own lawsuit. They just don't, right? 8-year-old child in a car accident doesn't have capacity to bring their own lawsuit. And so what happens is the court will appoint a guardian ad litem. The court actually has to give the parent the power, like just being the parent's not enough. The court actually has to give the parent the power to bring the lawsuit on the child's behalf. So it's kind of like that. The interest and the legal rights belong to the corporation. It's not the shareholders' rights that are being vindicated, it's the corporation. So this is the style of lawsuit that it is. But the corporation's been injured. Why? Here, director, or the corporation is paying for huge contract prices. They're paying, right? They're paying inflated contract prices. There's no competition, so these construction companies, et cetera, are charging massive, huge amounts for these contracts that are being awarded. So the corporation's paying these inflated prices for these contracts, and the directors are causing the corporation to do that. Why? Because the directors are receiving bribes from these companies. So pad my personal pocket, and then I'll award you this contract. And I'll make the company pay you way more than it otherwise would. So we don't have free market forces now determining the cost of projects, which injures the company drastically. And politicians, I mean, whenever you have some sort of construction project or anything like that, you have to get zoning relief, you have to get some sort of government approval for really everything, right? So the politicians, their pockets are being padded by the construction companies so that they can go ahead and advance their interests as well, go and get through any red tape. So, and that's also injuring the company. Money is being stolen from the company. So you can see, obviously the shareholders are injured because the company is going to be valued less when you have this terrible news come out, just like Tesla, right? The SEC wanted to sue Elon Musk because he started saying really interesting things on Twitter, and the share value went down drastically. That sucks for shareholders, right? Because now their stock's worth less. So you can see there's damage there, but it's also bad for the company. So there's harm in both places. So identify the harm and who's vindicating the harm. So that's the harm there. It's massive. So it was a $98 billion lawsuit. What does that mean? It means that when the plaintiff filed their lawsuit, they demanded $98 billion. They told the court that's what they wanted. That's what they apprised their injury to be, right? Of course, when you settle, you never get what you want. I always go and ask at least for, I don't know, if I want $100,000, I ask for $300,000, right? And that's just what you do. That's way more. Then you have room to negotiate. It looks like you're being so generous by coming down. But $98 billion, you're going to see they settled it for a lot less. Yes.
Wait, so is that $98 billion of just the damage to the corporation, not including the damage to the shareholders?
Well, so it was a shareholder derivative suit, so it was brought on behalf of corporations against corporations.
So then, do the shareholders have to do like a separate class action lawsuit for damage that they got, like personally?
Well, if the corporation, I mean, ultimately they're the ones who benefit from this, right? Because if the corporation, if the money gets infused back into the corporation, then the corporation has a stronger financial standing, and then their shares are going to be worth more. And you'll see when I show in the next videos the stability that this settlement brought to the marketplace in terms of, yes.
The stolen money from political parties, are we just saying the inflated money?
Money from the corporation was given to political parties, so that the political parties and the political
So the
decision
directors
makers.
basically allocated money from the corp to political parties.
Right.
Okay. How do they, what was the guys?
Okay, so for example, the NRA. Where does most of their money get spent?
Trump campaign.
Lobbying, right? Lobbying.
They're lobbying.
To get to lobby the legislature for laws that are consistent with their belief system. Planned Parenthood, all these different organizations. The reason why they lobby and why they fund campaigns and why they have these political action committees and they pay for really expensive commercials and things like that is because they want to change people's minds and get people elected who will make choices that are consistent with their beliefs, right? And that'll help their company's bottom line. So companies have an interest in having people elected who will make choices that benefit the company. And that's why for a very, very long time, we had laws in the United States that would cap the amount of money a corporation can give to a campaign. And then there was this huge lawsuit, went all the way to the Supreme Court called Citizens United, and that's when the Supreme Court decided that corporations, because there are people too, corporations are people, not humans, but they're people, that they can now donate to political campaigns and things like that. So you have business interests now helping to guide political interests, which is interesting. So there's a lot there.
But was it Citizens United that first said that corporations are people?
They're not the first people to say it, but they're the loudest because it's the Supreme Court.
Oh.
Once you get this opinion on it.
But like that idea was like already out there before this lawsuit?
Yeah, it was just extended. Like, we always call them people, you know, because they can sue, be suable property, do a lot of things people can do, right? But now we've extended that to also being able to have a political voice. There's that concept of one person, one vote, right? So are we going to allow corporations to essentially vote as well? So, and it's more dynamic than that. It's a very long opinion. There's a lot of issues there. That's one of the interesting ones. Okay. And full disclosure, I'm not like the stock and bond and corporate securities and this kind of person. That's not my thing. Not my thing, so full disclosure. But I am interested in the litigation strategy and the fundamentals of corporate governance and corporate ownership. I mean, all the legal work I've done, the corporate legal work I've done has been in the context of smaller businesses, right? So I've dealt with shareholders, but it's always, 10 or less. Okay.
Being a Verizon engineer is about doing things right, and there's no shortcut to the right path.
They want me to skip it.
The nation's first 5G ultra-wideband.
We're going to make this up at maybe cost at 15 seconds.
So Paula, tell us what this might mean now for the future of Petrobras, the company.
The settlement is actually good news for Petrobras. I know that almost $3 billion sounds like a large amount, but investors were expecting something around $10 billion, investors at Morgan Stanley, for example. So the settlement came in at a lower cost and came in earlier than anticipated. People weren't expecting it to be this early this year. So the shares reacted positively, and it sent a very positive sign to the market. JP Morgan, for example, said it removed like the most significant uncertainty on the company right now. It was a large overhang.
And what about the economy more broadly and the presidency? So Michel Temer had been caught up in this. Now what happens and who becomes president next?
That's a very interesting question. So we are heading to a very uncertain election. We have no favorite candidates. The whole market here expects a centrist, market-friendly candidate that has yet to emerge. We have no signs of this person yet. So it's really interesting that investors are so positive with corporates in Brazil, and that's basically because Brazilian corporates have matured enough to inspire confidence at this point.
Do settlements always get widely publicized like this? Is there like an amount where they can just hide it?
Yes and yes. So a settlement like this is huge, huge news. I was actually, I remember where I was when I got the text from my friend telling me this case settled. I was like, what? Because it's literally the biggest settlement ever. And the attorneys get like or something. I mean, they have to prove it up. They'll probably have to, okay. They will definitely get a very, very huge portion of the settlement. So are they always publicized? When it's this, it is. Like, this is big news, and it's public. It's public because it's a publicly traded corporation. And so, of course, the settlement is public. The fact that the lawsuit is public. Remember when we looked at the SEC filings when we started our corporation segment, and I had you guys go look at the legal section, and it would disclose any lawsuits that were pending. So Petrobras, every single year or every single quarter in the SEC filings, they have to disclose the existence of this lawsuit. And so when the shareholders look at these disclosures, and they're like, oh, well, when she said shareholder confidence, it's like, well, should I invest in this company? Should I stay invested in this company? What should I do? Should I sell it? They're trying to make informed decisions that impact their financial bottom line based on the disclosures that are being made to them. And when there's this lawsuit that's been filed for $98 billion, well, everyone knows that, you settle for a fraction of what you demand. That's just common knowledge. But what's that fraction going to be? The big difference between $10 billion and $20 billion and $30 billion and $2 billion, $3 billion, right? So it really makes a big impact. So the reason why this was public is because it's a publicly traded corporation. They have to disclose the fact of the lawsuit. The lawsuit's filed in court, and all court records are open. So you can actually go to any single court and you can get any records. So court records are open unless they're sealed by the parties, and it's very difficult. I've had to seal records before. It's very difficult to get records sealed. So any lawsuit is public. Settlements, however, settlements have to be approved by the court if it's a class action lawsuit, and there's a special procedure by which we do this. I'm actually working on a motion for preliminary approval right now in one of our class actions. So for like a little less, more than $1 million is exciting, but less than that. So you have to lobby the court and prove that it was a fair, reasonable settlement. It's in the best interest of the class. It's adequate. All these different things, right? So you have to file the settlement agreement with the court and motions and declarations and stuff proving like we worked hard on this case, we did our discovery, we found all the evidence, and based on what we found, this is a reasonable settlement, right? So that's public. If it's not a class action lawsuit, the settlement's not filed with the court. And there's usually a provision in the settlement agreement that has no press clause and a confidentiality clause. And if they're smart, they'll have a liquidated damages provision that says like if you breach this confidentiality clause, then you owe money back if the settlement's done to give money back, right? So for example, just because you smiled, I think you're interested in this story. For example, there's a kid, not kid, freshman in college. I believe she was a freshman in college. Her dad worked for a school as like the superintendent of the school, of a high school, prep school on the East Coast. So like a really nice school where kids go and live away, wear little uniforms, all that, right? So, and he's the superintendent or whatever you call him. He files a wrongful termination lawsuit against the school, for some employment case. They settle with him for about $60,000. And within the settlement agreement was a confidentiality clause. It said, if you disclose this settlement, then you have to give the money back. But your claims aren't renewed, you're still settled. And why might a defendant want a confidentiality provision? Doesn't ruin the name, exactly. Because a lot of times defendants will settle a case like I just told you they settled for 60 grand. Does that make you think maybe they did something wrong? Right? Like it's just common knowledge, like, well, why would you pay something if you didn't do something wrong? Most people think that. Well, not everyone knows how expensive lawyers are. Not everyone knows it's going to cost $150 just to get through that 1 week trial, right? So frequently we call that a cost of defense settlement, where they'll just pay just as like go away money, right? And the go away money just is expensive because lawyers are expensive, right? You know, $60,000 is not a lot of lawyer time. So they settled. They wanted it confidential because they don't want people to know. And also future plaintiffs. They don't want future plaintiffs to know maybe what they could get out of them. Yes?
I was going to say also, if there are people that think that there's a lot more money to be gained, it'll encourage more lawsuits and more lawsuits.
Yes, exactly. It shows that, you want it to be a secret. So for all those reasons, well, his daughter knew about the settlement, and she wrote on Facebook that she was so excited to be going on spring break thanks to the X number of dollars that her dad got from the jerk company he used to work for. And the company saw that. And so then Dad had to give the money back. She was probably grounded.
You are not planning spring break.
Yeah, so I mean that's the answer to your question, and those provisions are enforceable. So sometimes they're confidential. When they can be, they will be. But sometimes when it's a public issue like this, it's a class action, it's all public information anyway. And you can go pull up the settlement agreement. You can go online and pull up the settlement agreement if you're interested in reading some 37-page. Read as fast if you're having trouble sleeping.
Like, to what extent does it have to be confidential? Like, if that guy was married, did he tell his wife? Or was he allowed to tell his daughter, but she just wasn't allowed to post it?
Well, that's a spousal privilege, so they wouldn't even be able to ask his wife if he ever told her. But you usually, the confidentiality provision usually says that you can disclose the fact of the settlement, but no more. And there's usually a no press clause, which says you just have to say no comment. No comment, no comment, no comment. So but yeah, you can disclose the fact of the settlement, but that's also public information, because if you go look on the court website, you'll see that the case was settled and dismissed, and the plaintiff had dismissed the case with prejudice. So everyone already knows it's settled, so that's all you can disclose. You can't disclose any of the conditions or terms or anything like that. So he shouldn't have told his daughter. I mean, she doesn't share the legal rights. He could tell his wife. I mean, he shouldn't. If she's not a party to the litigation, he technically should not tell her. But because it's the wife and there's a confidentiality, they could never depose her and find out if he told. They could never, there's a privilege, that's privileged communication with the husband and wife, so.
Because I just feel like the money's gonna like end up, in his bank account.
Yeah.
They're just gonna see it.
Right, yeah. But he shouldn't tell his kid.
Yeah, I know there's something, I don't know what it was called, maybe it's the same thing, but like, say he did something wrong and he told his wife cannot, like, she can't tell on him, more or less. Something like that, right? Like,
There's various spousal privileges where you can't compel a spouse to testify against the interests of another spouse.
yeah.
So if you get in trouble and someone knows about it, you marry them so they can't testify against you in court.
Yeah.
No, that's not right. I mean, that's one of the reasons. Okay. Kidding. Okay, so here is, I just want to show you that I posted a few other articles about this. If you're interested in it, it talks about the kickback scheme and all this stuff. It's a really, really interesting case. I don't have time to get really too much deeper into it, but it's really fascinating stuff. We won't be testing you on the content, but it's a really, but what you will be tested on is understanding shareholder derivative lawsuits, how they work. I think this is a great illustration of, it's the biggest thing financially to hit in your lifetime. It's the biggest corporate wrong by bad actor directors to hit in your lifetime so far. Okay.
Are bribes illegal in Brazil? Are they illegal?
Yeah, so instead of calling bribes, otherwise it'd be like confirmation.
So they're illegal in every country?
Right. So, I mean, because what is a bribe? It's, I'll give you money to do this for me. That sounds like a job. Unless this you want to be done is illegal, which makes it not compensation and bribe.
But that's sort of standard practice in other countries. I think that's what
Yes, sir. Oh, yeah.
So they wouldn't call it a bribe, that's just how you do business.
Exactly.
So that's, I think, what she's trying to say.
Yeah.
Is that common business there, or is that actually a bribe?
I mean,
I was gonna say,
The
like,
kind of
if it's in a country where it's common practice, it's illegal, but no one's gonna enforce it and no one does anything about it.
right. Unless it's on this scale,
Right.
which is
Yeah.
huge, right? I mean, what is it saying, like you give them an inch and you take a mile or something? Little wiggle room goes a long way.
So if you're going like 66 and 65.
I mean, yeah, it's bad. I mean, they got in prison. There's people, no one gets jail time. It's so rare someone for a corporate bad act gets jail time in the United States, or like a politician gets jail time. The only politicians, I mean, there are some, but the most recent ones I'm aware of are like the Flint, Michigan water crisis politicians who diverted the water flow from a refinery to like the river and started bringing bad water into the residents of Flint, Michigan, and these kids were drinking water with lead in it. Now, 2 years later, they can now study the harmful effects of it, and the miscarriage rate is 3 times what it was because of that, right? So those politicians are being imprisoned, but it's really rare here. I mean, that's, the United States politicians are in prison, and we're way more strict. They're not as strict in Brazil, and here you have like 10-year prison sentences, so you can imagine the scale of it. Okay, we were on slide 18. Okay, so more bad acts. I guess we can't get enough of it. This is, I encourage you to learn more about Enron. It's very influential in shaping the current state of the law.
Most of us are familiar with the infamous Enron scandal, and here's what I'm guessing most people know about it. The company cooked the books and pulled off some shady accounting tricks. They were caught, and now cease to exist as a result. But this is a very thin understanding of the subject. There was so much stuff that went down, I can't even do it justice in a short video like this. If you want to become an expert on it, there's a movie I can recommend. It's called Enron, The Smartest Guys in the Room. It's nearly 2 hours about the scandal, and honestly, I think that's even rushing it. The entire ordeal is so complicated that there could easily be an entire college course centered around it, and that course would be for the advanced students. Wouldn't it be great if someone created a YouTube video that concisely explained it in a way that's both entertaining and easy to understand? Enron formed through a merger in 1985 between two energy companies. That's what Enron was, by the way, an energy company. When I say that, it's a huge simplification because Enron was involved in so many things in complex ways that the average person didn't even come close to understanding exactly what the company did. It was founded by a man named Ken Lay. You may want to remember that name. Now let's fast forward around to the year 2000. It was a fantastic company and very attractive for investors. At the time, they were thought of as being one of the world's leaders in business. I would say it's like how we view companies like Apple and Google today, but that's not even close to how amazing Enron was. They were making money and growing at a rate that no one had ever seen before. So here, I'll pretend to be a financial advisor helping you decide which stock you may want to buy. Here we go. I've looked over all the numbers, and I strongly advise you to invest in Enron. They're one of the fastest growing and most respected companies around today. I'll just show you a few numbers to support my advice. As a financial advisor, I look at companies' revenue, debt, and past stock trends. Here's Enron's revenue over the past 5 years. Just look at that growth. It's quicker than I've ever seen. I also checked out their debt, and it's very reasonable compared to their equity, meaning they're in great standing with creditors and have very little chance of going bankrupt. And as far as stock trends, here's a graph showing the stock price over the past few years. Just 3 years ago, they were in the $20 range. Today, it's well above $80. I've been advising clients to purchase this for some time now, and I've yet to have someone disappointed by their decision, except one guy who decided against it, and he's kicking himself right now. Plus, while I was reviewing their year 2000 annual report, it was filled with statements straight from Enron themselves saying how they're expecting future growth and success in the future. So Enron is well respected, has incredible revenue growth, low debt, and a solid history of unheard stock growth. So what do you think? Do you want to invest in Enron? Okay, I'm done being the advisor right now. Since I couldn't hear your answer, I'll assume you said yes. You want to invest in Enron. And if you said no, that's a foolish answer at the time. Based on the information available, practically anyone who knew anything about the stock market would say to jump on it. So now you've invested heavily in Enron. Now let's fast forward 1 year and see how you did. So it turns out the stock didn't go up like everyone had projected. In fact, it's gone down just a tad. What was in the $80 range when you invested is now in the 50 to 60 cent range. So you've effectively lost all your money. I'm making light of it here, but there were thousands of people that experienced this, including the Enron employees. They invested heavily in 401ks and retirement plans that were tied up in Enron stock. And really, can you blame them? But Enron went bankrupt in December of 2001. Thousands of people lost their jobs, retirement funds, and any other money they had invested in Enron. So what happened between this year and the last? As it turns out, all these numbers I just showed you were just an illusion. Back when I was your financial advisor, I was advising you based on false numbers. Take the revenue I just showed you. It's all fake. How so? Here's what Enron did to make it appear so high. It's thanks to something called mark-to-market accounting. Its effect is basically being able to recognize revenue when you have no revenue. Here's an example of something that actually happened with Enron. In 2000, they signed a 20-year contract with Blockbuster. Enron thought the contract would result in profits in excess of $100 million. So only 3 more years and the contract between Enron and Blockbuster will be expired. Well, obviously the contract didn't work out, and was actually doomed from the start. It had to do with bandwidth and internet streaming, but the technology didn't work, and Blockbuster ended the contract. Here's the problem. Enron recognized over $100 million in revenue from the deal. It doesn't quite seem like they earned $100 million in revenue from the deal, yet they reported $100 million in revenue from the deal. Then, as an advisor, I looked at that number to tell you that you should buy Enron, and they did this far more than just the Blockbuster contract. All they had to do was project some earnings, and boom, they had earnings. It essentially allowed them to put any number they wanted in that earnings column. Another thing I looked at when advising to buy the stock was their liabilities. Well, as you may have guessed, their liabilities were completely false as well. How they pulled this one off is a little more complicated. But in short, they set up side companies and pushed the debt over to them. So all of a sudden, Enron's debt problem was solved. Obviously, they still had the debt, but it was no longer on their financial reports, and therefore non-existent as far as investors can tell. I also looked at the stock trends. These high stock prices were a result of investors being fooled by these numbers for an extended period of time. So the stock was trading for over $80 per share, whereas if the company hadn't pulled these accounting tricks, it would have been trading for a fraction of that. There were numerous other accounting frauds committed, but these were the biggest and most impactful. But there's another part to this. What about the auditors? The job of an auditor is to look over all these financial statements to ensure the company's position is fairly represented. Every public company legally has to have their financial statements audited. The primary purpose of an auditor is to prevent things like this from happening, so the investors can confidently use the reports to make informative decisions. Had the auditors done their job properly, they would have seen red flags all over the place, but they weren't doing their job properly. They weren't really doing it at all. They were being paid by Enron to look the other way. The name of these auditors? Arthur Andersen. At the time, there were 5 major accounting firms: Deloitte, KPMG, PwC, Ernst & Young, and Arthur Andersen. Almost all major companies would use one of these accounting firms to audit their financial statements. Now it's down to 4 major accounting firms, because Arthur Andersen didn't survive the scandal. See, an auditor survives by their reputation. When investors see that PwC audited a set of statements, they trust that they're accurate. But now, if Arthur Andersen audits something, the investors are still questioning whether or not it's accurate, which makes investors avoid the company. So all of Arthur Andersen's customers switched over to one of the other 4 firms. The auditors didn't do their job in detecting it. But who's responsible for the fraud on Enron's end? 2 executives from the company are pretty heavily blamed: Ken Lay, who I mentioned earlier, and Jeff Skilling. They were both found guilty of conspiracy and fraud, among other things. Skilling is set to be released in February of 2019, and Ken Lay is dead. He died of a heart attack in the time between the verdict and the sentencing in 2006. He was 64 years old. There were several other people involved in the scandal, many of which walked away with millions of dollars and sold their stock right before the massive drop. This scandal, along with others like it at the time, promoted a new set of accounting rules that dramatically changed the accounting industry, because it clearly wasn't functioning perfectly. Now auditors have much stricter independence rules. Also, the CEO and the CFO have to certify the financial statements, so they can't later on deny that they ever saw them, which happened with Enron.
On the date I left, I absolutely, unequivocally thought the company was in good shape.
Again, this was just a brief review of the scandal. Some of the things I didn't cover include intentionally causing power outages in California, Ken Lay's ties to former President George W. Bush, Enron's involvement with the election of former Governor Arnold Schwarzenegger, how everything was ultimately revealed, and much more detail about the individuals responsible and how much they profited from the whole scandal. If you want to hear more about any of these, I recommend you watch the full-length movie I mentioned earlier. And I just want to say, it's important to remember that all the shareholders who lost money from the scandal weren't bad investors. They were victims. Victims of crimes committed by Enron and Arthur Andersen. The information they were using to purchase the stock was promised to be accurate, when in reality it was far from it. At the time, Enron's bankruptcy was the largest bankruptcy ever to occur in American history, which makes this one of the biggest scandals in American history. Now that it's over 15 years old, we can all look back at it at a safe distance as one of the most interesting scandals in American history. Let me know in the comments any thoughts you have on Enron, Arthur Andersen, or anything else I discussed in the video. I'd like to hear what you have to say.
Enron is a company that deals with everyone with absolute integrity. We play by all of the rules, we stand by our word, we mean what we say what we mean.
Thank you for watching.
I wonder if Simpsons created
Probably did. If you learn anything in this class, if there's one thing you take with you from your time here, is to question everything. Don't believe anything completely anything, like you have to digest it, think about it, analyze it, and then in the framework of what works for you, make choices. Like even things I tell you, like, and why do I say that? Because when I explain something, I'm using words I'm explaining something against the framework of my understanding, and I think I'm communicating it clearly to you, right? But you're hearing that against your framework and your context and your backdrop. So you're going to take in something different than what I say, no matter what. Hopefully the difference is so minuscule that it has no impact, right? But like I was telling you a few weeks ago, this like brain science book I was reading, and this guy says there's no such thing as immaculate perception. You never perceive anything 100% as what it is, because it's all against your interpretation. So, you know, people that sign up for things that it looks too good to be true, or whatever it is, or like trusting anybody, like always just trust yourself. Trust yourself. You know, you're accountable to yourself. But analyze, problem solve. It's tremendous. As a lawyer, I get to see so much of this. Injury born by reliance. Injury born by reliance. All right, so kind of odd placement of the Enron between committees and committees continued, not sure why. But let's talk a little bit more about committees. Committees in the context of the board of directors, right? So we have our board of directors, our numerous member board of directors, and like, you know, a few will branch off into the various committees. One really important committee is the compensation committee. So they are the committee members comprised of directors who are reviewing the compensation for the directors as well as for high-level employees and officers. Another important committee is the shareholder litigation committee. They decide when and whether to sue directors for mismanaging the corporation. So in the event of a shareholder derivative lawsuit, when the shareholders decide amongst themselves that they want to sue, they have to tender that lawsuit, that claim, to the shareholder litigation committee. And if the committee chooses not to proceed with the claim, that's when the shareholders will go separately to court, but they have to tender it to the directors. There's also the audit committee, which I think we talked about last class, and they're the ones who work with the auditors, hire the external auditors, and make sure that that process is going. And again, that's required of all companies. Which is why who's going into audit?
Who's going into that?
Oh, yeah. That'll keep you all so employed because of these laws. It says everyone has to have one, right? Yes.
So in our case that we had where that Guppy or whatever, these 5% shareholders sued the company, did he have to go through this committee? Because it looks like this is suing the same people.
Right, so it's like this, so the...
He brought the lawsuit.
Yes. Technically they have to tender the lawsuit to the shareholder litigation committee, but if the shareholders can prove that that would be futile, then they can just go straight to court.
So for test purposes, should I mention that in like an analysis or?
Yeah, it's like a first step, you know. But if the people on the committee are so corrupt, that obviously you're just going to be giving them the ammunition for your case. Then
So, yeah.
Wait, so the shareholder that is bringing the suit is the one that has to say that it's futile. That's why they're going to bring it to the board, right?
Yes.
So you could say that about anything, right?
Right. They have to prove, yeah, well, these shareholders, these board members are so corrupt, these are people that would be implicated in the lawsuit, so why would I bring it? Right, so, and usually they can prove that, because if there's a situation that's egregious enough to bring a lawsuit, then it's,
Probably.
yes. So technically, it's just part of the rules. So, who can be a director? Well, anyone can be a director. In California, there must be at least 3 directors unless there's less than 3 shareholders of a corporation, in which case there must be as many directors as there are shareholders. You can have a 1 shareholder company, right? Someone incorporates themselves, they're a sole proprietor and incorporates themselves with the only shareholder, so they are also the only director. But if there are more than 3, then there have to be at least 3 directors. And they're voted in by the shareholders again. So how do they vote in directors? There's a few different ways. This came up on your pre-test. So under straight voting, the shareholder casts as many votes for each nominee as he or she has shares, and the top vote getter is elected. So this is what permits that shareholder owning 50% of the company to effectively control the corporation, because they're voting in directors they like, because they can cast as many votes for each nominee as they have, right? So if there's 5 positions, they can cast as many votes as they have for each of the 5 positions. Class voting is a little different. Class A, Class B, etc. So this is one way that they make sure that every class of shareholders, and different groups of shareholders, have adequate representation. They give certain shareholders rights to elect specified number of directors. So a certain class of shareholders will elect these directors, and other shareholders will elect these seats, fill these vacancies. And that makes sure everyone gets some sort of representation, and it helps avoid having some majority shareholder effectively control the entirety of the board. Then we have something called cumulative voting, and that permits a shareholder to multiply their shares by the number of directors to be elected and cast the votes in total for one or more of the directors. So if there's someone that has 100 shares and there's 3 positions open, this will allow that person to make their vote more meaningful. There's 3 positions open, so they have 300 total votes, and they can cast all those votes for one person. So that's one way that these other minority shareholders can make their vote more meaningful and be heard. And the voting method that the corporation utilizes will be set forth in the operating agreement. So what happens, with these public corporations, if you're a shareholder of Apple, like anyone own shares and actually go to the shareholder meetings? No, no one goes to shareholder meetings. I have a video of one for you so you can see what it looks like. But no one goes to shareholder meetings. People have what they call proxies. So once public ownership of shares exceeds 50%, management must solicit proxies from passive shareholders to have a quorum and achieve a valid shareholder vote. So passive shareholders are just, like us, right? We're not going to the meetings and actively engaging. But if we're not actively engaging, the corporation needs a quorum in order to act. So that's when the proxy system comes in and still helps the corporation function with a quorum. So proxy is a person designated to vote for the shareholder, and there's something called the Wall Street Rule, talks about it in the book too. If you are a passive shareholder, you're not really paying much attention, you're just going along for the ride, you either support management, like whatever initiatives they want to pass, you vote in favor of them, or you sell your shares. Like you can be a passive obstructionist, right? You're passive and you go with it, or you're not passive and you're out. So that's the Wall Street Rule. So here is,
Could you just define quorum?
Quorum. Okay, so quorum is that minimum number necessary in order for an entity to make a choice. So we get the decision makers in a room. For example, the board I was on, we had a really hard time making quorum. And that was really annoying. And that's one of the reasons why they were frustrated that I would take a year off, because I was always there. I always showed up. But if you have 11 people on the board, and you need your quorum is a simple majority, how many people need to be there for the corporation to vote on anything? 6, right? So we needed 6 people to show up, right? So there are times when we couldn't get 6 people to show up, and then we have to reschedule an emergency meeting because we'd have to make decisions. Like we'd have to vote to approve of the executive director signing a contract, for example, or with our employee pension plan, things like that. Like we have to make certain choices, and you can't make those choices without the quorum. So it's that minimum number of decision makers that have to be present in order to empower them to make a vote. And then once you have quorum, you need just a majority, and under our rules, you need a majority to pass the resolution. So we would need 4 of the 6 to pass the resolution. So, which means 2 people could vote against it or abstain, whatever, but you need a majority of the quorum. You don't need a majority of the directors, it's a majority of those present. And we have some long-standing directors who I think just had some institutional fatigue. They've been involved for 20-something years, and people have competing interests and schedules, and it becomes very difficult. And that's the case I gave you, about a director not attending meetings. There are cases where directors are sued for breach of fiduciary duty because they're just not attending meetings. They're not doing the research, they're not attending meetings. In advance of the meetings, you're given all the financial reports, and we have our accountant will come in every single month and present, and she'd give us all these statements, and that's not my space. I'm a lawyer, I'm not an accountant. I mean, I did well in accounting for lawyers, and I focused on corporate partnership tax in law school, but that was like forever ago, and I forgot all of it. But in order to fulfill my fiduciary duty as a board member, I would have to get these reports, these like 20-page reports, understand them, read through them. I have to sit down with someone and talk about it until I can get a place where I can actually make a meaningful choice based on it. So it's a very labor-intensive process. But that's what's necessary to fulfill your fiduciary your obligation. You can't just show up and be like, yeah, that pay looks good, vote for that. You can't do that, right? So that's quorum, that's the importance of the decision making, and another example of just the practicalities of some of the challenges that boards face now, especially like nonprofit boards, where the boards do a lot of work, but don't get any compensation. I was wrong. All right, so here's I show this video just so you can get an idea in your brain about what the shareholder meeting looks like, because again, you've never been to them, and it's just, I like to show a visual because it just sounds so random. Like, is it in a classroom like this? Like, what's it look like?
So Tesla just held its annual shareholder meeting in Mountain View, California, and the timing is super important. Elon Musk almost lost his chairmanship of the company, and he faced serious questions about Tesla's finances and future. That's because right now, that future is looking more uncertain than ever.
My trust in Tesla's timelines sort of eroded a little bit with the Model 3 ramp.
This is like, I'm telling you, the most excruciating, hellish several months I've maybe ever had. We've made a lot of mistakes with Model 3 production, but we recognize those mistakes and we're confident we know how to address them. Reliability and capability of autopilot will increase exponentially over the next 6 to 12 months. I think I do have like an issue with time. This is something I'm trying to get better at. So I'm trying to recalibrate these estimates.
So why are investors so nervous? Well, first of all, the rollout of the Model 3 isn't going well. This is Tesla's cheapest car yet, and it's the key for the company to go mainstream. The Model 3 is also Tesla's best chance to make its first ever profit. It says it right here in Tesla's quarterly financial statement. Future business depends in large part on our ability to execute on our plans to manufacture, market, and sell the Model 3 vehicle. And then a little further down, it reads, we have no experience to date in manufacturing vehicles at the high volumes that we anticipate for Model 3. But so far, the Model 3 production has been a mess. Tesla failed to hit several important deadlines. There have been major bottlenecks in the factory, as well as a few fires, forcing the company to shut down its assembly line so it can fix the problem. Meanwhile, almost 500,000 people who have reserved Model 3s are left wondering when the hell they're going to get their cars. So the goal was to be making 2,500 Model 3s a week by the end of the first quarter, but as of April, Tesla was barely managing to make 2,000 cars a week. The new goal is to make 5,000 cars a week by the end of the second quarter, and that deadline is coming up fast. Meanwhile, there have been a bunch of investigations into unsafe working conditions at Tesla's factories, and the company is burning well over $1 billion in cash every quarter, prompting questions about Musk's ability to keep Tesla afloat without raising more money. Its stock price is trending downward, and Musk is complaining about big media. The stock price suggests investors aren't happy, and some stockholders have even filed a class action lawsuit claiming Tesla made false and misleading statements about the Model 3. And we haven't even gotten to autopilot. That's Tesla's super advanced version of cruise control that takes over a lot of the driving from the driver. There have been a handful of nasty car crashes in recent weeks involving autopilot, including one that resulted in someone's death. The feds are investigating, and these incidents are raising the question, is Tesla marketing autopilot correctly, or is it possible that the system isn't as safe as the company says? Musk is struggling to produce a mass market car. If the Model 3 fails to live up to its potential, that means Tesla's valuation is all out of whack, which will probably cause its stock prices to fall even more. And if the stock price falls more, then Musk might not be able to raise money, Tesla will run out of cash, and the dream of a mass market electric car will be dead. If he succeeds, then all that skepticism will shift to one of Tesla's other future products, like the Tesla semi-truck, the next version of the Roadster, or the solar roofs from the mysterious Model Y. Tesla can barely manage to handle Model 3 production. How well do you think it's going to do with the rest? I think Elon would appreciate that if I recycled this, right? This could be a future Elon Musk here. So Tesla's super important. Elon Musk.
I just want you guys to know how hard I try to find videos that are informative and entertaining, because this stuff can be so boring. Like, there's other videos out there on the same topic that you should watch before bedtime. Okay, so here's the deal. It's 12:11. Let's talk about the rest of the semester. okay? Because we're closing in on it. And as we get deeper into the semester, my expectation shifts, so I want you to know the content, but what's more important is that you know how to solve the problems, because we've been working on problem solving, we've been facing a lot of real life situations, real life examples, and on your exam you've seen that it's just problem solving and asking definitions, etc. So what do we do with all this content and how do we balance it? How do we study for the exam? How do we prepare for the exam? The way I want you to read from this point forward is to have the PowerPoint with you and read the book in the context of the PowerPoint. So if the PowerPoint completely ignores something in your book, you can skip over that section. If the PowerPoint touches on it, you need to understand that and know how to solve problems related to that. You notice I don't always go over all the chapter problems that I assign. They pop up on exams, they pop up. Those are, when I assign chapter problems, my point is, this is what I want my students to be exposed to. Of all these chapter problems, if they can solve these, this is what I think they're accomplishing the goal of the class. So I value your time. I know you have a lot going on, and so this is how you can save some time in your reading and focus on what's important. And spend more time on your chapter problems that are assigned than on the cases. I mean, read the cases and brief the cases, but if you're going to invest time, I want you to invest it in the problem solving. If you want to come to me, please come see me in my office hours. I'm also there way outside my office hours, and there are a lot, so come spend time with me. We'll talk about anything. Finally, we've expanded the office hours for our tutors through finals. So the tutoring hours are on the BLAW website. They're fantastic. I don't know if any of you have been to them, but they're very, very helpful. People who go really big help. So the tutors hours expanded. That's an investment we're making you. We pay for them. And there's also tutoring in the business honors department. So if anyone has any disconnect, if your grade is not where you need it to be, come see me, see a tutor, do something.